Intellectual property. This is one of the more fun topics, if fun is the right word, for this course. I think most business students find it interesting because many of you want to be in business for yourself, and intellectual property is an important aspect of that, as we'll go through the different types of intellectual property. And a big picture point is that some of these types of intellectual property we're going to be discussing apply to all businesses, or virtually all. Some of these, not so much. For example, very few of us will ever register a patent. Very few of us will need a copyright for most of the things we do. But one or more of these apply to many different businesses. So I'm going to begin with sort of a discussion about why this is important in the law. And then we'll begin to move into the different types of intellectual property, covering all four, starting with patent. This is Thomas Edison, the world's greatest inventor, at least in terms of number of patents, but I don't know how many of you know because it's seemingly forgotten today. He not only invented the incandescent light bulb, which he's holding, the first practical light bulb. He invented essentially the record player. The first person in history to make quality recordings. He invented the motion picture camera. He actually invented the stock ticker, the device that kept track of stock prices electronically. He's quite a guy. Well, obviously, he needed patents for these devices, and he had many patents. I don't remember how many it is, but it's in the hundreds. Some of you may be familiar with his long-standing battle with Nikola Tesla over AC, DC electricity. And it's a very, very interesting story. But the moral of that story is while patents are important, an unfortunate aspect of patents is often the litigation, the lawsuits that follow it. And even 130 years ago, or whatever it was, Edison and Tesla seemed to be in constant battle in courts. This is Bob Dylan, one of the great songwriters of the last probably 50 plus years. Obviously, he has published many, many songs. He needed and needs copyrights. And he has many copyrights. We'll talk about copyrights specifically. But Dylan wrote songs that he recorded. He wrote songs, there's a lot of famous songs that other people recorded. And the copyright he held in that obviously brought him a lot of income. He, like many songwriters, no doubt sold some of his copyrights to publishing companies, and we'll talk about that. So copyrights cover a number of different areas, but certainly musicians use them. I think you know what logo that is, and that brings me to the point about logos. Trademarks, big picture, are designed to protect logos, branding, slogans, business slogans. And almost every business has a trademark of some sort or another. And then the one I don't have on the slides, but that we will talk about briefly at the end, is trade secrets. And so let me just wrap up the big picture point. Very few people have patents. Larger companies often do. They tend to be for electronic, like cell phones and manufacturing, airplanes, things like that. Not too many of us will need copyrights. Most businesses have trademarks of one type or the other. Everybody has trade secrets, as I say in the notes. Now, the purpose of this slide is to make a big picture point about the significance of intellectual property in our economy. And I make the point in the notes that once upon a time, most businesses were in the manufacturing business. It was hard goods. If you go back into the 1800s, it was making steel, making machines, and certainly cars, airplanes, and that sort of thing. That stuff is still made, of course, but the economy has moved more and more to an intellectual property type of economy, meaning that the the products and services provided by many major companies are not hard goods. I mean, yes, Apple makes cell phones, but behind it all, the real value of Apple is in the technology, the electronics. The phone itself is a relatively small piece of that. And as you can imagine with electronic companies in particular, but also other companies, Disney, the branding, so much of the value of these companies is tied into the brand, into the copyrights, and into the designs and so forth. I used to keep up with this. A slide I would show the value of brands, companies that, how much money, just the brand itself, like Coca-Cola trademark and that sort of thing. It's hard to keep up with it. It's constantly changing. But for some companies, virtually the entire value of the company, the vast majority of it, is wrapped up in the brand, in the intellectual property itself. And what makes that challenging is that intellectual property is not easy to value. And I use the example of, a company has developed this really, really cool new invention of some technology. They have tremendous hope for it. They think it will have value. But if you're an accountant or somebody who values these sorts of things, how do you value an idea? How do you value a design that has not yet been implemented? And how in the world do you value a brand, a trademark? Again, I don't remember the numbers offhand, but Coca-Cola, the value of Coca-Cola Company, an extraordinarily high percentage of that is tied up just in the Coca-Cola brand logo, the intellectual property. So anyway, you get the point. It's a very, very big deal. Now, these are the 4 types of intellectual property we're going to cover in this order. They are completely distinct. They sometimes can sort of overlap. For example, a company that makes personal computers and that also develops software for those computers actually will need both patents and copyrights, general rule. In fact, this is a good one for the quiz. This is not an absolute, but it's a general rule. So remember the general rule. General rule is that hardware for computers is covered by patent, and that software, the code, is covered by copyright. So that's a good one to remember. And as we go through each of these, we're going to have, I mentioned this in the notes as well, a series of important questions. In other words, if you know the answer to these questions for each of the 4 types of software, of intellectual property, then you're going to do pretty well in the quiz and test. In other words, this is a good thing to remember, this list of questions for each of the 4 types. Okay, so I will run through it. First, the first question asks for each type of intellectual property as we go through this. Is it necessary, legally necessary, to file a registration with some governmental entity in order to have legal protection? Ultimately, it doesn't do much good to have a copyright if you can't enforce it in court. And rarely do these things end up in court, but you need the backup of the court if necessary, to cause other companies to back off if you get into a dispute. So when I talk about legal protection, that's what I'm talking about. It turns out, of the 4 types of property, intellectual property that we're going to be discussing, registration is available for 3 of the 4. That is a registration with a government entity. For one of them, this is a teaser, registration is the only way to get legal protection. And for the 2 of the other 3, registration is available, but it's an option. There is a way to receive legal protection basically through the common law. If you do register, where? And I mean literally federal, state, and what office at the federal level. Don't worry about the Kansas registration when we get to that. It's just a general point. I mean, that is where. For one of the 4 intellectual property interests, you can register at the state of Kansas and at the state level. The other 2 that have registration, purely federal. So that's the where part. Duration. For the ones that do allow registration, there is a time limit. And you need to memorize those time limits, obviously. And then the final point is, once the duration has expired, can that intellectual registration be renewed? And again, it turns out for one of them, it can be renewed forever, in theory. For two of the three, the registration that's permitted is a one-time deal. Once it expires, it expires. Another big picture point I want to make is that intellectual property is very important today, of course, but it always has been. In the Constitution of the United States, there is this statement. Basically, it was the framers of the Constitution granting to the federal government the power, and in fact the word power is even used, to promote the progress of science and the useful arts for a limited time to the authors and inventors of their respective writings and discoveries. Now, copyright was certainly known back then. I'm not sure, I don't even know what the copyright laws were in the United States early on, because they would have been through Britain. And Britain did have some copyright laws, but they weren't very strong. The reason I know that is I read a lot about Shakespeare, and when Shakespeare died, he didn't even bother to put anything in his will about his works. And part of the reason it's thought is because they had so little value in terms of copyright protection. Obviously, that's changed a lot over the years. That is, copyrights today for books and records and movies and things is a really, really big deal. But the big picture point here is that the founding fathers, the framers, recognized the importance of incentivizing people who dream, people who have ideas, people who are creative. This is focusing primarily on patent and copyright, because we want to encourage people to build a better mousetrap, to build a better machine, to build a better cell phone. And we sure as heck want them to be incentivized to find a cure for cancer and other diseases. And the patent is designed to protect people who invent things, who come up with the new designs, the new ideas. And this provision actually mentions writings by name, so we do want to protect those who create works of art. So it's actually in the Constitution, and this is the constitutional basis for federal protection of primarily patents and copyright and later trademarks. Now, we're going to start on patents, and so this is a good example of a patent. This is one of the most famous photographs in American history. I think some of you probably know who they are. This is Wilbur and Orville Wright, the Wright brothers. This is a photograph taken at Kitty Hawk, North Carolina. I don't know if it's the very first flight, but I think it is, in 1903. And that is their plane. And some of you may have seen it at the Smithsonian. This is a drawing of the plane and the patent. And in the lower right-hand corner are Orville on the left and Wilbur Wright. Now, I read a book about them recently. I really recommend it. It's by David McCullough, called cleverly The Wright Brothers. And it's sad. In some ways, they've been forgotten. It's a marvelous book about these two guys. But, it's one of those things where they were absolutely determined to build an airplane that was functional. Many people around the world were trying to do that. They got it off the ground, literally. And then they proceeded to spend the next several years, it seemed, in court, fending off people, trying to protect their design through patent. In fact, Wilbur, on the right, who David McCullough calls a true genius, was the one who led that patent fight. And he actually died relatively young, and don't know if it had anything to do with all the litigation, but it probably didn't help the strain and stress from that. So they couldn't even really enjoy their invention. At Wilbur's death, they were still embroiled in court over the patents, but history has remembered them well. There are other kinds of patents. The thing about patents is it covers a very broad, in fact, it's hard to explain what is covered by patents. Some of you know who this is. This is The Edge from U2, and he is playing a Fender Telecaster. The drawing on the right is the patent. And by the way, when patents are registered, they typically have to have a drawing attached. You are presenting your idea to the public. It's in the public domain. And this is Leo Fender, Clarence Leo Fender, who invented this particular type of guitar. For those of us who play guitar, I have a guitar exactly like the one that The Edge is playing, same color and everything. That's why I use this picture. And for those of us that play that type of guitar, it's kind of a big deal. So there's the design for that particular guitar. So let's talk about patents and the more technical side of it. First of all, there are national or federal patents, and those are filed with the United States Patent and Trademark Office, USPTO is what I'll refer to it as. And the other drawing is to show that there are a couple points, actually. One is that there are international patents. I don't spend much time at all in this class on the international law aspects, partly because it's really technical and it's kind of confusing, but the main point is that for patents, trademarks, and copyrights, there are ways to protect your idea through international law. And in a very simplified manner, what that means is nowadays, if you file your patent and trademark and it's accepted by the federal government and copyright too, it is automatically sort of registered through international treaties. And by the way, the only countries that are bound by this international law would be the countries that have signed off on those treaties. And that's why the treaties are a big deal. But that has long been a real issue. This idea of trying to protect, it's hard enough to protect your patent and so forth nationally. Imagine trying to protect it internationally. And so therefore I will give you an example. And this example also, the story I'm going to tell you about a client of mine, is really to make 2 points. One is the international aspect, but also just the practical aspect of the costs and the hassles of getting a patent. We represented a relatively small to medium-sized manufacturing company in Wichita. They make some really cool things, including, without going into details, electronic devices. And I did quite a bit of legal work for him. I got a call one day from one of their VPs, and he said, I need to see if you can help us. We're having a problem. Here's the story. He said, our company had designed a product a few years before, had manufactured it, and were selling it to a foreign government, actually directly to the government. It was actually something used in some military machinery. Okay, this country was on the other side of the world, and it wasn't China, and things were good. Life was good. Well, then what happened is one day they are contacted by this foreign government and told, we don't need your product anymore. They basically canceled the orders, canceled the contract. And my client then checked in and found out what had happened is that some company in the other country had gotten a hold of my client's product, reverse engineered it, and started making it there for a lot less money than my client could sell, especially given the shipment costs. So the question to me was, is there anything we can do about this? I then asked what I think is a logical question. Do you have a patent for this particular device? Because I'm thinking if you do, then we need to see if it's protected by the international treaty, et cetera, et cetera. And they said, no, we don't. So, first point, why didn't they have a patent? I asked them that question too, to which they said, getting a patent is really expensive. Not the filing fee with the federal government. The filing fee with USPTO goes up all the time, but it's only a few $100. The expense is in hiring the patent lawyers. It's a very specialized area of law, and waiting years sometimes to get it approved and going through steps. And a lot of companies, and this is a very important point, don't even want to mess with that. Now, if you've invented something that's completely unique and innovative and is worth billions of dollars and millions of dollars, okay. But they had made a conscious choice not to get a patent. That's a very important point. So then then I was thinking in terms, and I was talking to him, I said, okay, even if you had a patent, let's talk about that. And this is what I want you to think about. What if they had had a patent? Could that have helped them in this situation? And the answer is, in a legal, technical sense, yes. Because there would then be the possibility of going through some process to get my client's patent enforced internationally. Here's the practical problem with that. First of all, the country in question is an ally of ours and is a signatory to all these treaties, so that was theoretically possible. The practical problem is my client, while they made quite a bit of money off this product, it wasn't in the millions. I mean, we're talking probably more like hundreds of thousands rather than millions. The cost of hiring attorneys on the other side of the world to try to enforce it, and then to get hometowned in that country, and then to prove it, because lots of times other companies will make the argument, hey, we kind of came up with this on our own. It's not as easy as it sounds. So even if they had a patent, it would have been a long, expensive process, and we may not have won. My client was actually fairly philosophical about it. Oh well, we took a chance and it didn't work out. We'll move on to something else. Now let's talk about the typical types of patents. There are actually several different types. We only talk about two in this class. One, and this is the most important because it's the standard, that's the name of it, standard patent, sometimes called utility patent. This is the one that's used for most stuff, that is new designs, new products, if you design a machine, this is the one you're going to use. It applies to most stuff. It is supposed to apply to a new and useful process. It also covers manufacturing processes, machine, article manufacture. Very important, it is 20 years. You get 20 years exclusivity, but it's from the date of the application submitted to the USPTO, not from the date the patent is actually approved, and that can be a year or two difference. You get one shot, 20 years exclusivity, and that's it. No renewal. Now, I want you to know a little bit about this. I'm going to, for the most part, for the lecture, talk about the standard patent. A design patent is a separate type of patent. It's not for the product itself. It is for the design of typically the packaging, like a Coca-Cola bottle. This is a design patent, if I recall correctly, for a Coca-Cola bottle, or at least the type of Coca-Cola bottle that's used. You can recognize the old style. So some companies will actually get a design patent for packaging, okay, and the duration there is 14 years. We're going to focus primarily, as I said, on the standard patent, which is the machine itself or the process. What do you need when you submit your application to the USPTO? What do you need to do to convince them that they should accept your patent and approve it? And I should point out, it is difficult. I've known people who have submitted applications for patents and been declined. It's very frustrating. A friend of mine, I haven't seen him for quite a while now, was a patent attorney. Talked to him a little bit about this. And by the way, there are very few patent attorneys in Wichita. I mean, literally a handful. To do patent law, you have to be registered with the USPTO as a patent lawyer. It's one of the few areas of law that is officially specialized by certification. And he was an interesting guy. He had been an engineer for many years at Boeing and then decided to go to law school and become a patent attorney. And it worked out really well because when he sat down with his clients to prepare the application of the drawings as an engineer, he had a real advantage. But here's what you need. You need to show the USPTO that your idea is novel, useful, and non-obvious. And what that means is, by novel, it means it's something new. You have to convince the feds that you've come up with something truly new. It's not too close to other things that are already out there. Has to be useful, and don't worry about the useful one too much because that's kind of self-evident with most stuff. Novel and non-obvious are usually the two hurdles. Non-obvious, this one is technically different. There are sometimes the USPTO will decline a patent saying, well, It is a little bit different, your idea, than previous machines, previous designs out there, but it is a non-obvious extension of the previous idea. Obvious. It's an obvious extension of the previous idea, meaning it's a logical step in the next iteration of the product. Now, if that sounds confusing, it is only because it is confusing, and this is why people get so frustrated with applying for patents. Note the quote here from the court case. That's the U.S. Supreme Court, by the way. You cannot patent a law of nature, a natural phenomena. What that means is mathematical formulas and scientific discoveries are not patentable. So Newton's brilliant discovery of gravity and a whole bunch of other things would not be patentable because the idea is it's out there in nature to be discovered. What do you get if your patent is approved? In addition to the exclusivity period, what do you really get? You have an exclusive right to manufacture the product. Literally, you can preclude other people from manufacturing a product based on your patent. Or you can license the patent to multiple users. This is something some inventors do. They don't want to mess with starting their own manufacturing company. And so what they do is they license it. They go around to different companies and say, do you want to use my idea? I'm going to give you an example in just a few minutes. It's very famous. And you get royalties from that based on a per unit. Like how many units did they buy? $10 per unit, whatever it might be. The third option would be to sell the patent. And this is really critical. You actually sell it completely. You assign it is the technical term. And you assign over ownership to the new person. So if you look up the patent online, USPTO, and you can, it would show the patent holder as the assignee, not the original inventor. In other words, you sell it for a total price. I want to make a quick point about drugs because the manufacture, the development of drugs is such a huge deal today. With all the dread diseases, there have been some amazing, there's been a lot of amazing progress in drugs for some diseases, HIV/AIDS being one, but there has been some encouraging developments with cancer drugs recently. I happen to know a little bit about this through some friends who are struggling with cancer. And immunotherapy is kind of the new big deal. But there's a lot of money that's put into this by drug companies. And you may be aware of this, but the dilemma here is that a drug trial, a new drug, takes so long to be approved by the FDA, Food and Drug Administration, because of scientific concerns. Many of the people who are dying of these diseases, they can't wait. And so there's always been this tug of war about, well, are we going to, on top of the FDA approval, it takes years to get patents. So the thing I want you to know is that there is a federal law that tries to address this by giving a sort of temporary and quicker period of exclusivity for a drug company rather than wait until the very end for all the patent stuff to go through. It's to incentivize them to go ahead, because if you don't give them some exclusivity in the meantime, then other companies can come in and steal their ideas, and that's bad for all of us. And by the way, this is another thing to remember. A generic drug is a drug that the patent has expired. So this is a good idea to talk about R&D. Here's the basic idea. You have, let's say, a terrible disease, and 3 drug companies are working feverishly to try to come up with something. In fact, a better example is Alzheimer's. Alzheimer's is just devastating. About 1/3 of our healthcare dollars, I think it is now, are going to Alzheimer's care. There are several drug companies that are working very, very hard on trying to come up with something that slow it down, even theoretically cures it. They've not had much progress. Imagine the research and development costs for working on a drug like that. It takes years and years, and the odds of success are very slim. If you succeed and you get a patent, then you've got 20 years of monopoly. A patent is a legally protected monopoly. But you may not succeed. And if you don't succeed, you've expended millions and millions of dollars for what ultimately is a dead end. The whole idea of patent law is to encourage, incentivize these companies. And if we didn't give them exclusivity period, they wouldn't even do it. But what happens is, let's say they do get a patent for the drug. They get the 20 years, if that's the applicable time, for the exclusivity. And then the 20 years is up and it becomes part of the public domain. That's the whole idea of a patent. It's out there for everybody. And what happens is when the patent on some of these famous drugs expire, other drug companies are waiting in the wings because they now have your formula. You had to give it to them through the patent to then come to market with the same drug. And it's called a generic. So when you go to the drugstore and you're looking at a generic version of whatever it might be, Tylenol et al., and you look at the ingredients and you say, well, they look to be the same. They are the same. At least the active ingredients are. But we'll go ahead and pay 3 times as much for the brand name, and I do it too. But that has to do with the effectiveness of marketing and branding, not logic. Okay, now patent enforcement. There is a federal, that's U.S. Congress, Lanham Act. It covers actually both patents and trademarks. And it is the statutory basis for the cause of action. So if somebody has a patent and somebody else is allegedly infringing on it, which means using that patent in their own manufacturing, the lawsuit is brought under the Lanham Act. And this is really critical, the second bullet point. The plaintiff does not need to show that the defendant was intentionally using the patent. It's not an intentional tort. The idea is if somebody's using your patent, they're using your patent and it's still harmful to you, whether they intended to or not. Now, I will say that for the most part, they do know, because usually before the lawsuit's filed, a cease and desist letter is sent by the attorneys for the plaintiff. Because litigation is so expensive, they would rather not sue. And what they usually try to do is send a cease and desist letter saying, okay, here's what we have an understanding that this is what you're doing. You're using our patent. This is how much it's hurting us. We'll give you 30 days to stop or we're going to sue you. And I've seen those before, those kinds of letters in Kansas because of alleged patent infringement. So that's the way that works. Now, before I go on to the next example, one of the things I want to mention here, because it's somewhat related to patent enforcement, and that is this question I've had from students over the years as well as clients. You've just come up with this great idea for design. You don't want to go to the trouble and expense of a patent. Is there some way you can protect yourself legally short of going for a patent? And let me give you an example. We've seen this in Wichita a number of times. Our law firm did. Guy comes to our firm and says, I've got this great idea for a new machine. I want to pitch it to an angel investor or a company, an existing manufacturing company. I just want to see if they'll help me. I will bring the idea to them, and if they're interested, we'll work out an arrangement where they manufacture it and then we figure out a profit split. It'll be their investment, my idea. It's actually a really good idea. It's done quite a bit. Can I protect myself if I don't have a patent? And where I've seen this come up is where somebody wants to approach a company and pitch the idea. And this could be a business plan, which is a copyright issue, but right now I'm talking design. But they're afraid the company may say no and then later steal it and use it. And then it's too late, essentially. And one way you could do it, this is something I really wanted to stress here, and it's a good idea to consider, is have a lawyer write for you what's called a non-disclosure agreement. Remember that, non-disclosure agreement. It's a contract. A basic idea, and again, I've seen this done. Somebody goes to Boeing, Cessna, whatever, Learjet, and says, I've come up with this really cool new idea for an airplane part. I don't have a patent. I'd like to present it to you and see if you're willing to manufacture it and pay me a cut. We can work out a contract. But before I show it to you, I'm going to have you look at this non-disclosure agreement, which says you promise that you won't steal my idea, that if you choose to use it, you'll enter into a contract with me and pay me and not steal it. It's worded much more elegantly than that. But that's actually a pretty good way to protect yourself on the front end. Now, here's the problem. You can only use a contract with one party at a time. A patent is the whole world. And that's why a patent is so much better ultimately. Now, the example I'm going to give you, I've been using this one for a while. There's actually a movie. The lower right-hand picture is from the movie. It's called Flash of Genius, and some of you may have seen it. I actually never have seen it, but I've heard about it. And I knew about the situation before the movie came out. The guy in the lower left is Robert Kearns, and he actually lost an eye on his wedding night from Champagne Court, and he blinked a lot, and he got the idea of intermittent windshield wiper motors from that. Before Dr. Kearns, and I believe he was a professor, windshield wiper motors were on or off. Some of them still are. And he came up with a patent, actually a whole bunch of patents, for what many of us are familiar with, intermittent windshield wiper. In other words, intermittent speeds. And he got patents, and he then went to a bunch of different auto companies and tried to license it to get royalties. So he'd go to Ford, he'd go to GM, Toyota, and so on. And incredibly, they all turned him down. But later, they all stole his idea. Not all, but most of the companies stole his idea and started making it. And the reason was he's just some professor. He doesn't have any clout. He doesn't have any money. This is a classic case of just ripping this guy off. He had the patents. They just didn't think he was willing to take them on. Large corporations can use litigation as a business strategy. Well, he was tenacious, and what the movie's about, from what I understand, is his efforts to get back at these companies. I actually first heard about this way before the movie. I knew an accountant who worked for a large firm back east who was working on one of those lawsuits where Dr. Kearns had sued Chrysler, and the accountant was one of the expert witnesses to testify about the royalty value. And I still remember him many years ago saying his opinion was that each motor, and there are 2 per vehicle, had a royalty value of 90 cents. Now do the math. Several car companies had been using his design on millions of cars for years. He did eventually get a bunch of money, but it took a long, long time. Now, I'm not going to go through the details of this case. I've got 2 slides on it. You can read it. It's an important case because it's the U.S. Supreme Court, and it has to do with a very important issue because of DNA and all of the developments about genetic coding of disease. It has to do with the question of, can a drug company get a patent for breaking down the genetic code of a disease of genetic mutation? This case had to do with breast cancer. I do want you to remember that. I'm just not going to go into the massive details here on the lecture. It's a very serious issue. As you can see what the numbers are, women with this particular mutation had a much higher rate of cancer. This particular company had decoded it and had developed a medication for it. This is huge. And they got a patent. That is, the USPTO actually issued a patent to this company. A competitor brought a lawsuit saying, hey, they can't get a patent. This is a scientific discovery. This is a critical point. What the court said was that the patent holder could legitimately get a patent for developing the synthetic chemical to treat this disorder. That's like any other drug. But it could not legitimately get a patent for genetic DNA sequencing, because that's just nature. It's out there. It's for anybody to discover. They just happen to be the first. This case is critically important for this kind of thing going forward and is, as you can imagine, controversial. But it does show that scientific discoveries themselves, things in nature, are not patentable. So remember the breast cancer case. Prior art defense. This is an interesting defense. It applies only to patent cases. And the basic idea is this. The patent office should not issue patents to designs, ideas that are already in the public domain. Not just are already patented, but that are in the public domain. It has to be novel, right? But here's the kicker. The patent office's job is not to search the universe to see if that particular design, idea, and so forth is in the public domain. The burden of proof, in other words, is on the person applying for the patent. So here's how it works. It's based on a case I worked on, and it was a glow-in-the-dark golf ball case. A company, I believe it was Arizona, developed a particular manufacturing process to make a golf ball glow in the dark for night golf. It never caught on here. In Japan, it was huge, but there was a thought at one point that night golf was going to catch on in the United States. And so this company developed it and got a patent for the manufacturing process. Now, not for the idea of a glow-in-the-dark golf ball. It turned out that's been around since the 1920s. But there was actually several patents, different manufacturing processes. The lawsuit came about in federal court because, oh, by the way, the Arizona company had sold the patent to a Wichita company. And so the Wichita company was actually a patent holder, not the inventor, but the patent holder. And my client was a catalog, one of these upscale catalogs where you buy products. And the catalog company, as it turned out, was selling a glow-in-the-dark golf ball made in overseas that completely infringed on the U.S. patent. In other words, somebody was deliberately using the idea from this patent, but they were overseas. Well, the catalog company didn't know, but remember, intent is not a necessary element of proof. So we had a problem. My client was in deep doo-doo until one of my brilliant young law partners came to me and said, hey, there's this thing called prior art defense. Meaning, if this patent, which was issued, let's say, 2010, if this patent, at the time it was issued by the U.S. government, if the idea behind this manufacturing process was already in the public domain. Okay, how do we prove that? He said, well, I found an article that says this exact process was proposed in Japan years before the patent was issued and actually ended up in a Japanese patent application that was declined. But it was in the public domain. It was like in a journal, a newspaper, whatever. And I said, great. Can we get a hold of that Japanese patent application that was declined? And we realized that we had we belonged to an international organization of law firms. We had a Japanese partner. So we sent them a communication, and they sent us a copy of the patent application. It came in very handy in court. And here's why the prior art defense is so important. Not only would the plaintiff have lost the case against the catalog company, okay, if the prior art defense is used and the court agrees with it, the court basically is saying this patent should never have been issued because it wasn't novel. It already existed. And again, it sounds like I'm blaming the USPTO, but no, the burden of proof was on the company that presented the patent in the first place. So it's a very serious defense. We're now moved to copyright. A copyright is designed to protect the tangible, that means see, touch, expression of artistic works, not the creation itself. This is something I try to explain in the notes. So I have to use an example for it to make sense. There are people who are so gifted in songwriting that they can just be walking down the street and an amazing new melody pops in their head, almost entirely all in one piece. And I've heard some famous songwriters talk about this, in interviews and stuff. So let's say, I'll use Paul McCartney because he happens to be one of them. Paul McCartney of the Beatles, walking down the street, and he just has this melody pop into his head, the whole melody. The most recorded song in history is the song Yesterday by the Beatles. Paul wrote it. He says that he woke up one morning with the entire melody in his head. He dreamed it. So it's not beyond the pale. So he's humming the melody walking down the street because he wants to make sure he doesn't forget it. He's going to go back to his house later and put it down on a tangible form. What is tangible form? In the MP3, a recording on paper, notation, lyrics, whatever. But it's in his head. He's just singing it. Somebody hears the melody, hears Paul humming it. They think it's great. They steal it. They go. They record it before Paul does. They copyright it before Paul does. Who wins? The answer is the person who stole it, because you can't protect the song, the idea in your head, the words to a poem in your head. What's protected is the copying of a tangible thing. This is why copying machines in libraries have copyright warnings and things like that. So it's actually a very important distinction. Registration can be obtained with the U.S. Copyright Office. It's strictly federal, no state. But registration is not required. In fact, most copyrights probably numerically come about through non-formal, registered means. I'll talk in just a moment about how can you do that. First, let's talk a little bit about the registration itself. If you choose to register, you submit, you put in a request to U.S. Copyright Office, and these are pretty easy. This actually can be done online. For the most part, they're just going to accept it. They're just noting that here it is. Here's the song. Here's the architectural design, and so forth. We'll talk in a few minutes about what you can copyright. Here's the numbers, very important. When you get a federally registered copyright, the copyright holder, that is the designer, the person who came up with the idea, it is valid for 70 years after that person's death. So a songwriter, 70 years after death, that's to protect the estate. Elvis, the Beatles, whatever. That's a long time, but it does protect the estate. If, however, the person who originally copyrighted, if they assign that copyright to a publishing company, like a music publishing company, a book publishing company, a movie company, the publisher then has a valid enforceable copyright for 95 years after the death of the original creator. Example, John Lennon of the Beatles died in 1980. He sold much of his music that he wrote with Paul McCartney to Apple, not the Apple computer company, but the Apple Music Company in England. And Apple actually held the copyright. In fact, later, Michael Jackson bought most of the Beatles' catalog from a publishing company. That's how it works. Once you sell it, you lose control of it. And so the point is, the songs that John Lennon wrote, the copyright would be in existence till, I guess it would be 2075. That's 95 years after his death, if it's held by a publishing company. And there is no renewal. You get a one-time protection, although it's a very, very long time. What can you copyright? You can read it, the books, music, films, also business plans. I've talked to some students about the importance of copyrighting a business plan. General rule is computer programming, as I said, also architectural drawings. I've mentioned this for patents, but the same thing applies to copyrights. You cannot copyright a mathematical formula or scientific discovery or a historical interpretation. Now, let me mention how you protect yourself, because I don't think I have it on the slide. And that is, how do you protect yourself if you don't register? Registration is specific. You do it through the U.S. Copyright Office. The law now provides that you can have a valid copyright if you simply put your name and the year of your copyright on paper, electronically. So, for example, if you were to write a business plan and you printed it to distribute, you would put your name and the date, which would include the year, on it. And that is enough. It sort of presumes you're notifying people, I am copyright. Now, I still think it's a good idea to put copyright, the word copyright, to let people know for sure that you consider it something to be copyrightable. Now, whether it ultimately is copyrightable or not, it doesn't hurt to claim it, particularly if it falls into one of these categories. Some of you may be familiar with the little small c in a circle. That used to be required by the law. It does not. It's not required anymore. It's name and year. So remember that. The name and year is really all that's necessary. Now, this is to give you an example. You can search copyrights on the U.S. Copyright Office website. I pulled this information off years ago. This is the copyright for yesterday. It shows the original songwriters, John Lennon and Paul McCartney. This is one of those deals. It's kind of I'm a music trivia buff, and Paul and John had a deal they made early on as teenagers where they shook hands that every song they wrote, each of them, would come out under both names. Most Beatles songs were written by either John or Paul. How can you tell? If John sings that it's a John song, if Paul sings that it's a Paul song. Sometimes they would edit each other's work. They almost always played it for each other, and the other might make comments, but the words and music generally were written by one or the other. For you Beatle buffs, the song A Day in the Life on Sgt. Pepper, which recently was voted the best album in history, has both John and Paul singing separately at different points. That's because those were actually two songs they wrote, smashed them together, and it's one of the rare cases. So you can see who the claimants are. It's their family members. You can see the original registration date, 1965. This one, I believe, was sold to the publishing company. And I've already made this point. These are the details about how you protect an international copyright. There's a major defense that's available for copyright lawsuits, and it is called fair use doctrine. And at universities, we hear a lot about this because we professors are copying stuff to give to students. Could be cases or parts of books and articles, or we make things available for students to read. And in a nutshell, professors worry way too much about this because one of the defenses in the fair use doctrine is teaching and scholarship. And this is oversimplified, but if somebody thinks that you've improperly copied something, and it is something that is being used for criticism, like movie critic, academic criticism, if it's for news reporting and editing, editorials, if it's for teaching and scholarship and research, generally speaking, they can't sue you. Now, I heard somebody one time say, and for academic stuff, a professor can't copy an entire book literally and hand out the copies. That certainly would be a violation of copyright. But we can take excerpts from it, copy it, and give to students, and generally that is acceptable. I wanted to give you a couple of famous examples of copyright lawsuits. This is probably the most famous example of a copyright lawsuit involving songs. There have been many others. The Rolling Stones sued The Verve for Bittersweet Melody and got some money, and Vanilla Ice was sued by Queen and David Bowie for, I think a lot of you know about this, Under Pressure. But this one was the most famous. This is George Harrison on the left of the Beatles. He didn't get to write very many music when the Beatles together. So when the Beatles broke up, his first big hit as a solo artist, My Sweet Lord. Some of you are familiar with it. If not, go to YouTube. And huge hit. Several years later, he was sued for copyright infringement by the publishing company that owned the rights to the song He's So Fine by the Chiffons. Turned out that the two melodies were identical note for note all the way through. Mr. Harrison lost the lawsuit. The judge said, I do not believe Mr. Harrison deliberately stole the melody. I think it's just that he had so many melodies in his head, but he still had to pay money because the idea is that melody that somebody else wrote was the basis of a song that he made a lot of money on. He had to pay many hundreds of thousands of dollars for the royalties for that. He was very bitter. And here's another example. It's starting to be really dated, but some of you are familiar with the Da Vinci Code by Dan Brown. I'm not going to go through the whole premise. Some of you have seen the movie, read the book. I remember the first time somebody told me years ago when it was wildly popular as a book, before the movies, people would say, hey, have you read Da Vinci Code? And I'd always say, nope. And people kept telling me what the basic plot line was, and I would say, well, that sounds like Holy Blood, Holy Grail, which I had read many years before. Here's the difference. The Da Vinci Code is a novel. It's a fictionalized account. The Holy Blood, Holy Grail purports to be a historical interpretation about some events, but it happens to be exactly the same story, essentially, that's in the Da Vinci Code. And initially, Dan Brown denied it when people asked him about it, but then after his publishing company was sued by two of the three authors of Holy Blood, Holy Grail, At some point, Dan Brown admitted, well, okay, my wife did read the book, and okay, yeah, maybe we used some. At any rate, he won the lawsuit, and here's why. It was English law, but it's the same basic law. The court held that Holy Blood, Holy Grail was not a novel. It purported to be one interpretation of some historical events about secret societies and so on. And you cannot protect by copyright an historical interpretation. Now, you could prevent Dan Brown from taking the entire book and copying it, which is plagiarism, but the theme, the plot line, was not protected because it was, had it been a novel, then yeah, maybe so. One final point about copyright before I move on is for music, the sheer difficulty of managing this. Technically, every time a band in a bar plays a cover song, they need to have permission from the copyright holder or pay them. And I mean that literally. There are many, many violations of copyright. It happens all the time. Years ago, I researched for a couple of clients and things. One quick example, I had a doctor client who did therapy, and he had put together a series of basically a tape from music records. And he was using this compilation of music as part of the therapy, as background music, soothing. And he asked me, is this a violation of copyright? Do I need to get permission and pay these song publishers? I researched it, and the answer is yes. I even wrote the publishing company and asked them to give him permission since it was for therapy, and they said no. So here's how you can get around that. If you're a restaurant, a bar, or a doctor, you could become a member of ASCAP. ASCAP is the Association of Songwriters, and you can sort of become a member, pay a monthly fee, and you sort of get permission to use it for all the songs kind of associated with that, and then somehow they figure out how to pay the songwriters. Anyway, ASCAP. So remember that ASCAP is a kind of a convenient way to handle this issue of copyright. Trademark. You're probably most of you are probably more familiar with the trademarks as such than the other stuff. Like I said, almost every company has a trademark, whether they think about it or not. It's a business name, it's a business slogan, it's a logo. These are examples of some very famous logos. Nike. Let me tell you the Nike story. I want you to remember this for quiz. I used to joke around in class. Gee, I wonder how much Nike paid the advertising company to develop a logo that's a check mark. And I had this image of the advertising people walking in. Anyway, somebody told me one time, a student looked it up. $25 was the answer. It's paid some Oregon student. Anyway, they did nicely. But these trademarks, these slogans are worth lots and lots of money. Now, a trademark technically is the mark or slogan for companies that sell products. Technically, a service mark is the same thing under trademark law for services. For our purposes from here on, I'm just going to use trademark for both. Basics. This is the one intellectual property right that you can register both federal and state. Kansas does have its own version of trademark registration, but you don't even have to register at all. And we'll talk a little bit about how you go about using that in the symbols. So, and I'll tell you what the registration process and time frame is for federal trademarks. For Kansas trademark, it's very cheap, it's very straightforward, and not very hard to get. I don't think most Kansas business trademarks need to be registered personally, but you can certainly do it. You go to the Kansas Secretary of State's office. So, again, another pretty good question, I guess, for quiz. Kansas Secretary of State for trademark, their website. Federal registration, if you choose to register. And by the way, why would you register federally versus not? It's a way of letting people know. It's a much handier way. They can look it up. It's like public notice. You can only get a federal registration approved. I've done these a couple times. If you're using the mark in interstate commerce, which means across state lines. If it's a mom and pop grocery store, you can't even get your business name trademarked anywhere. But if you're doing business across state lines, then you may be able to. This timing is confusing but very important. Your first initial registered trademark is good for 5 years automatically. And then during the 6th year, you need to renew it or it expires. Once you renewed it once, then you only have to do it every 10 days after that. And if 2 or more people are fighting over priority of a trademark, the priority date is the date that this particular mark was used in interstate commerce. In fact, one of the interesting things about getting a registered trademark is you have to show the USPTO that you've already used it. You actually do that first, and then you try to register it. In terms of symbols, very simple. TM means you're claiming a trademark. You put the TM after your logo, your name, business name. It means not registered. It's a common law trademark. You can only use R in a circle if you have a valid existing federally registered trademark. And just to nail it down, you can renew the trademark in theory forever, because here is one that's still in effect from 1892, Coca-Cola. That is the original Coca-Cola trademark logo. I think most of you are familiar with that. In terms of getting protection, these are 3 terms I want to describe for you that are very important. To get a protected trademark, the easiest way would be for it to be distinctive. In other words, you make up the name. Xerox was made up. Accurate was made up. So I've always encouraged people when they're forming their business to come up with something, if you can, that's really, truly unique. So anyway, just use your imagination, I guess. A descriptive term can be trademarked, but only if it has been taken on a secondary meaning. And what I mean, I'll give you an example of this in just a moment. But what that means is if it's a term that describes the product itself, it's very, very hard to get a trademark protection for it. Not impossible, but very difficult. And if it's a generic term, a generic term is the name for the product, there is no protection for that term. And I've always thought the best way to explain this is to use a real example. Now, Miller Lite actually was the first to come out with light beer years ago. And Miller actually spells it L-I-T-E. But very quickly, other beer companies realized, wow, Miller's making a killing from this watered down beer. So we're going to make some watered down beer and call it light beer. And what they did is they came out with Coors Light, Bud Light, Michelob Light, Michelob Ultra Light, all these different things. Here is the actual trademark for Coors Light beer. Notice that what it says. No claim is made to exclusive use of the words light and beer apart from the mark as shown. In other words, Coors can and did get a legal protection for the phrase Coors Light beer, as contradistinguished from Bud Light and so on. But the term light is descriptive. It is light beer. I think it should be called watered down beer. But it's light beer, and beer is the generic term. You can't keep other people from using the term beer in their name. So this is a really good example of how these terms work together. In terms of enforcing trademarks, it's also the Lanham Act. Same thing for patents. You don't have to show intentional infringement. And the Lanham Act protects even trademarks that have not been registered. So this is very important. This TM is actually very important. A lot of trademarks are not registered, as it turns out, even some fairly famous ones. A quick point about this. It used to be that when you registered a trademark with the feds, you could only protect the name, let's say, or the logo in connection with the product itself. Example, McDonald's is done okay. Many years ago in Wichita, there was a chain of McDonald's clothing stores. It was actually based in Kansas. McDonald's Burger Company could not prevent McDonald's Clothing Company from using the trademark name McDonald's because clothes, burgers, different. What happened over time is some very powerful companies lobbied Congress and said, some of us are so famous that anybody using our name, our logo, is going to be confusing to the public. It just is. And it's going to dilute the value, the asset value of our trademark. This law, it basically means if a trademark is very famous, the big boys, Nike, swoosh, McDonald's Golden Arches, whatever, and it's a distinctive mark, then no one else can use that at all. Okay? So it only applies to really famous trademarks, whatever that means. One final point, trade secrets. As I said earlier, trade secrets in some ways are the most important because every business presumably has a trade secret. Customer lists, market strategy, business plans, marketing strategy, and think of it this way, it's the stuff within a company that the company has spent time and effort developing for competitive advantage, and that if competitors got a hold of it, it could be economically harmful. That's the definition. You also have to show that a trade secret is something that you have gone to great deal of trouble to protect, and by keeping it confidential. If you've been telling people about it, it's not confidential. There is no registration of trade secrets anywhere. You can't register them. There are two ways that I know of that provide some legal protection. The first, you don't need to worry about for quiz or test, but to let you know, Kansas is one of those states that has a Trade Secrets Act. It's a state statute. And if somebody steals trade secrets from a company, they can go after them. Well, so what? I mean, the horse is out of the barn. This only does you some good later. You've already been harmed. So it's good to know that, but the one I want you to remember is the non-disclosure agreement. This is where you have your employees, for example, sign non-disclosure agreements that they will never disclose to anyone, and definitely competitors, your trade secrets. And if they do, you can sue them for breach of contract. And it's the holding it over their head that really has the best value. Not so much the lawsuit itself, but the fact that they're bound by a non-disclosure agreement. This is different than a non-compete. Okay? And there's no time limit. It's usually forever. So that concludes intellectual property.